JS Group. Today we have gathered here for the celebration of World Intellectual Property Day. This day is celebrated to raise the awareness of the impact how patents, copyright, trademark, and design affect our daily life. The role of intellectual property rights is used for encouraging innovation and creativity in society across the globe. The event was established by the World Intellectual Property Organization in 2000 to raise the awareness of how patent and copyright and trademarks are done. Today we have with us very honorable guest, very honorable speaker, Dr. Sudroshika Das Madam, Assistant Professor, Management Department of JS University, BE, MBA, MSc from Applied Psychology. She has also done PhD from IIT Kharagpur as well as PhD from USA also. She has the experience of 9 years in corporate as the HR manager from different multinational companies. Then 9 years experiences in academics also. She has written 3 books. She has 30+ research papers and book chapters. She is also involved into women empowerment in our very nearby Sundarban area also. So I would like to welcome our honorable guest, our honorable speaker, Dr. Sudroshika Madam. Madam, over to you. You can start.
Thank you so much. And it's really an honor to speak out here on International Intellectual Property Day. Sir, I would like a screen sharing. Can I do that?
Yes, ma'am.
Can you please enable me?
Yes, I'm requesting our host. Yes, ma'am. You are now. You are co-host now. You can. Ma'am, can you do that now?
Yes, it's being done.
Yes, yes. Yes, madam. Before starting, I will request that could you please on your camera.
I'm sorry?
Could you on your camera that I was telling?
Yes, but I have started sharing. You won't be, then I have to stop sharing.
So, yes.
Wait.
1 minute. Madam is not coming to now. Yes.
Is it okay? Wait. Yes.
Okay. Host, can you take the screenshot? What is that? Hello.
Let me know once it's done. I'll put it off and I'll start sharing.
1 minute. Okay, madam, done too. Amrita madam. Okay, madam, you can start.
Please.
Thank you. Yeah, can you see the screen? It's
yes, ma'am, we can see.
Visible now?
Yes, ma'am.
Yes. So a very good afternoon to all of you. So today is World Intellectual Property Day, 26th April 2022. So to start with, I would like to say, what is intellectual property? And with that, I will flow with its history and how world has implemented it and how it is implemented in India after how this with the stream of time it has come down to India and what the current government is doing to promote IPR. And lastly, I would like to say, since I am from the applied psychology background and management behavioral science background, I'd like to end up the session with a small note of 6 thinking hat. 6 thinking hat is like the types of creativity, the innovation one must go for if you are really looking for some great innovations, right? So let me start. is IPR. I hope I'm audible to all. World Intellectual Property Day is celebrated on the 26th of April to learn about the role that intellectual property, that is IP rights, play in encouraging innovation and creativity. The day recognizes the huge potential of young people to find new and better solutions that support the transition to a sustainable future. Intellectual property rights are the rights given to persons over the creations of their minds, their innovativeness. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Intellectual property protection is critical to fostering innovation. Without protection of ideas, businesses and individuals would not reap the full benefits of their inventions and would focus less on research and development. Similarly, artists would not be fully compensated for their own creations, and cultural vitality would suffer as a result. Now let's go back to the history of World Intellectual Property Day. The event was established by the World Intellectual Property Organization, that is WIPO, in 2000 to raise awareness of how patents, copyright, trademarks, and designs impact on daily life. April 26th was chosen as the day to celebrate World Intellectual Property Day as it coincides with the date when the convention establishing the World Intellectual Property Organization came into effect in 1970. So it goes back 1970, 50 years back. Now, why do we really need an IPR? It was so did it innovation stopped, the creativity stopped? Not say yes, because if you talk about most of the very important creations, both in the scientific world or in the cultural or in the literary world, or almost all happened in the beginning of 20th century, end of 19th century, and beginning of 20th century. So whatever we are talk about, light, fan, computers, normal telephone that was done by Graham Bell. Everything was done much before I appeared then. But then what happened? It is the, all human beings. There is a flip side of human mind. So it is to protect not the good thing, but to protect ourselves from the flip side of our mind. We are all human beings, all are basically a little bit inquisitive, and this inquisitiveness make them little jealous, make them like steal others good ideas and implement on their own. So most of us didn't have a proper idea about intellectual property and the different legal protection one can get to save their creations. Keep aside Indians, even till few years back, even the Western countries did not have much idea about this. Now, India is always lagging behind. Whatever happens worldwide, India takes it a few years after. So most US small businesses were not aware that their US patent or trademark did not protect them in other countries. If you are an exporter or you think you might want to export in the future, you will need to seriously consider securing protection for your intellectual property in those foreign markets of interest to you. So it is not only in your own country where you are innovating or you are using. If you really want to use it somewhere else, there also in that country, you need to save your IP. It is a good idea to get the appropriate form of IP protection before you start doing business in another country. Some US companies have found that foreign manufacturers have copied their products, packaging, and business plans, even though they had never done business abroad. Foreign counterfeiters can easily steal your products, pictures, brochures, and even small logos from your website and register the material as their own inventions in their own country if you have not registered it in that country already. For this reason, some US small companies seek trademark and patent protection in large potential markets well in advance of actually exporting those markets. Now, if you go a little back again, uh, we generally talk about IPR, but IPR can be divided into two major heads. Before that, on the national level, at 8293 or the Intellectual Property Code of the Philippines covers intellectual property and its protection. The IP code updated and consolidated the country's law on patents, trademarks, and copyrights in the light of emerging global issues in the field of intellectual property and in compliances with commitments under international conventions and treaties to whichever the country is a part. So it's an expansion of creativity, what you actually mean. So when we talk about intellectual property, it has got two major heads. One is industrial property and then the copyright and neighboring rights. Now, industrial property includes patents, trademarks, and other marks, geographic indications, utility models, industrial designs, topographics of integrated circuits, and trade secrets. On the other hand, copyrights and neighboring rights include scientific, scholarly, artistic, and literary works, examples of which are musical works, dramatic works, audiovisual works, paintings and drawings, sculptures, photographic works, architectural works, sound recordings, databases, and computer softwares, and other works embodied in the Part 4 Law on Copyright of RA 829. UPLB are in the form of inventions, utility models, industrial designs, computer programs, as well as literary, scholarly, and artistic works. Under the IP code, inventions are protected by the patents, utility models, and industrial designs by their registration. Now, if you go back more, if you want to see the background, the intellectual properties concept is not a new one, as Renaissance Northern Italy is thought to be the framework of the intellectual property system. A Venetian law of 1474 made the first methodical attempt to protect inventions in a form of patent, which allowed right to an individual for the first time. Now, the invention of the printing press and movable tile of John 1450 helped in the origin of the first copyright system in the world. So it goes back to 1450. But yes, there was not so much hues and cries as we are doing now with IPR. By the end of 19th century, new creative ways of manufacture aided caused large-scale industrialization accompanied growth of cities, the investment of capital, expansion of railway networks, and nationalism led many countries to establish their modern intellectual property laws. In this point of time, the international intellectual property system also began to take shape with the creation of the Paris Convention for the Protection of Industrial Property in 1883 and the Berne Convention for the protection of literary and artistic work in 1886. I doubt whether Rabindranath Tagore has actually had his copyright at that point of time. No, he didn't. Now, after so many years, Bharati, they all did, they had taken the copyright of Rabindranath Tagore's all works, but he never bothered to take any copyrights. though it started in 1886. The evidence underlying intellectual property throughout its history has been that the rewards and credits related with ownership of inventions and creative works encourage further creative and inventive activity that motivates economic growth. The convention establishing the World Intellectual Property Organization in 1967 gives the following list of subject matter protected by intellectual property rights. These are trademarks, service marks, and commercial names and designations. Number two, inventions in all fields of endeavor. Number three, industrial designs. Number four, protection against unfair competition. And number five, all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields. Next comes literally artistic and scientific works, scientific discoveries, and last but not the least is performance of performing arts, phonograms, and broadcasts. The role and importance of the intellectual property protection has been formed in the trade-related intellectual property system, which is called TRIPS agreement with the establishment of the World Trade Organization at the end of the Uruguay round of the General Agreement on Tariffs and Trade, that is all you know, the GATT Treaty in 1994. So let's see what is TRIPS agreement. The TRIPS agreement incorporates in principle every form of intellectual property and targets the complementary and firming standards of protection and providing for operative enforcement at national as well as international level. It addresses the applicability of general GATT principles and the provisions in international agreements on IP, that's the part one. It also builds standards for scope usage readiness, that is part two, informants, that is part three, acquisition and maintenance, that is part four of intellectual property rights. Moreover, it addresses related dispute prevention and settlement mechanism, that is the fifth part. Now, formal provisions are addressed in part 6 and 7 of the agreement, which cover transitional and institutional agreements respectively. The TRIPS agreement came into effect on 1st of January 1995, which covered trademarks, which include service marks as well, industrial designs, copyright and related rights, geographical indications, the layout designs, the informations which are not closed, which include taste and trade secrets, patents which include protection of new varieties of plants, computer programs, literary, scholarly, and artistic works by copyright. Now let us quickly see what these are. What are patents, what are novelty, what are industrial applicability. So patent is an exclusive, patent is an exclusive right granted by the state through the intellectual property office of the that country to a patent owner for a product, processor, or an improvement of product or processor for a specific period in exchange of the full disclosure of the invention. Patentable invention offers a technical solution to a problem in any field of human activity and must fulfill three basic criteria, that is novelty or newness, that should be totally new thing which has not been used previously. This is determined through a search conducted by an accredited patent office to determine if the invention is totally new and original. It has to be an inventive step. There must be a new invention which is related to it. As such, the invention must not be obvious to a person skilled in that particular art, but it has to be a skilled one. And industrial applicability, there must be some use for the invention. It can be a practical solution to a problem that can benefit the public. All three must be satisfied to obtain a patent. And invention has a term of protection of 20 years from the filing date of application. A patent owner has the right to prohibit any unauthorized person or entity from using, making, or selling his product or process. The right can also be transferred or assigned through licensing contracts. We have utility models. What are these? Utility model is also known as a patent. To qualify, the invention must be new and industrially applicable. It has a term of protection of 7 years without renewal. Next comes industrial design. What is this? This consists of composition of lines or colors or any three-dimensional forms which serve as a pattern for industrial products or handicrafts. An industrial design has a term of protection of 5 years, which can be renewed for 2 consecutive periods of 5 years. Then comes the layout designs of circuits, which is extremely important in today's world. The layout design or topography of circuits is commonly used in microchips and semiconductor chips for manufacturing. It has a term of protection of 10 years without renewal. New plants varieties to cover breeders' rights and protection of plant varieties. The Plant Variety Protection Act is signed into law in order should be new, distinct, uniform, and stable. The term of protection is 25 years from the grant of certificate of plant variety protection or trees and vines. All other types are protected for 20 years grant of certificates. Then comes a term which is very common to most of us, which is called trademarks. Trademark may consist of words, names, and first names, signatures, acronyms, among others. It serves as an indicator of source, a guarantee of quality, and an advertising tool. The right to a trademark is granted when its owner registers it with the government. The trademark has a 10 years protection renewable for succeeding periods of 10 years. Copyright. Copyright is the exclusive and legally secured right given to creator or authors for their literary and artistic works to prohibit or authorize the reproduction or copying of the work. It allows the creator to derive economic or financial reward from the use of his works by others and to claim authorship of a work and to have the authorship recognized. We have copyright applications. It's filed to the Copyright Division of the National Library and the Supreme Court Library also. Now, in 1485, the first system of protection of intellectual property came in form on the Venetian Ordinance historically. In England, the 1623 was followed by Statute of Monopolis, which extended right of patents for technology inventions. In 1760, patent laws were introduced in the United States. Between 1880 and 1889, patent laws of most European countries were developed. In the year 1856, in India, Patent Act was introduced, which remained in force for more than 50 years, which was later modified and revised and was called the Indian Patents and Design Act 1911. A complete bill on patent rights was enacted after independence in the year 1970 and was called the Patents Act 1970. Specific statutes protected only specific type of intellectual output. Till very recently, only 4 forms were protected. The protection was in the form of grant of designs, patents, trademarks, and copyrights. In India, copyrights were regulated under Copyright Act 1957, trademarks under Trade and Merchandise Marks Act 1958, patents under Patent Act 1970, and the designs under Designs Act 1911. Now, there had been many other acts which had been incorporated, which included Design Act 1911, which later on was changed to Design Act 2000, trademarks called the Trademark Act 99, the Copyright Act 1957. Again, the Copyright Amendment was done in 2012, and the recent amendments made in the Patent Acts of 2005. Other than this, plant varieties and geographical indications were also enacted in other new legislations. These are called Geographical Indication of Goods Act 1999 and Protection of Plant Varieties and Farmers' Rights Act 2011. When we come to India, the development of the World Trade Organization was a result of the international trade cells. And the framework of trade calls for harmonization of several aspects of Indian law related to intellectual property rights. The TRIPS agreement set minimum standard for protection of IPR rights and also set a time frame within which countries were required to make changes in their laws to comply with the required degree of protection. In view of this, India has taken action to modify and amend the various IP acts in the last few years. Now let's go through quickly this patent these new acts which have been modified. India, after signing the TRIPS agreement and forming part of the agreement establishing the World Trade Organization for the purpose of reduction of distortions and impairments to international trade and promotion of effective protection of intellectual property rights, became signatory. The Patent Act was amended to time in the year 1995, 1999, 2002, and 2005 to meet its obligation under TRIPS agreement. Further, it has been amended to support the various technological developments in India to match with the development of the international intellectual property laws. India has also made amendments in the intellectual property rights. The amendments were also aimed at making the Act a modern, harmonized, and user-friendly legislation for protection of national and public interests, along with the fulfilling of India's international obligation under TRIPS Act. Subsequently, the rules under the Patent Act have also been amended, and this became effective from 2003. These rules have been further amended by Patents Amendment Rules 2005. Thus, the Patent Amendment 2005 is now fully in force and operative. Then we have Trademark Act 1999. The law of trademark is also now modernized under the Trademark Act of 99. A trademark is a special symbol for distinguishing the goods offered for sale or put in the market by one dealer from another. In India, the trademarks were protected for more than 4 decades as per the provisions of the Trade and Merchandise Mark Act 1958. India joined the World Trade Organization from its inception. One of the agreement in that related to the IPR or the TRIPS in December 1998, India acceded to the Paris Convention. Now, this Merchandise Act was also amended. The same was later passed in the Parliament and replaced with Trade and Merchandise Act 1958 with the assent of the President on the date of 13th December 1999. The introduction of Trademarks Act 1999 has been provided to be very fruitful to India for going global in trade and commerce area. The salient features might be early only goods and services covered was by the registration, but in this act, the infringement has broadened the meaning as it is also includes unauthorized use of similar mark or confusingly similar mark where the goods and services which are very similar and create confusion or chance of confusion stands. Number 2 is even though where the unauthorized use of trademark is made of any well-known trademark of India and the interest of the owner is anyway fringed, the action of infringement can be taken against the same. Further, it gave more power to police by authorizing them to seize infringing material without any warrant issues. Then came the Design Act 2000. Science and technology started boosting up in the beginning of 20th century, and the urge to provide more reliable judicial system came in place for better protection of this field and for the protection of industrial design. The steps were required to be taken to promote more and more development in design industry by providing protection under registered design. Though it was very essential to protect the design only to the extent it was required and not any more than that, and to allow use of available design for free too. The current act is in line with TRIPS agreement and therefore line with globalization of trade and commerce. Then if I cut short this because it has got a lot of salient features, yes, there are a couple of it which is a little important, where the definition of the terms article design has been given in wide scope. The scope is given to the term prior publication. So that prior publication is absolutely necessary. Introduction of provision for delegation of powers of the controller to other officers and stipulating statutory duties of examiners. Provision of identification of non-registrable designs. provision of substitution of application before registration of a design, substitution of Indian classification by internationally followed system of classification, and provision for inclusion of a register to be maintained on computer as a registrar of designs. There are many more which were there, but these were the most important ones. Then came the geographical indications of goods, that is Registration and Protection Act 1999, where this act is new in India and recently introduced result of the event where turmeric, neem, and basmati were patented by persons outside India. To avoid letting outside misuse the Indian geographical indications and indicating the goods are not basically indicated from Indian locality. After such instances, it became necessary to have legislation for registration and providing adequate protection to geographical indicators too. The bill introduced in the parliament and passed, and with the set of the president, the geographical indication of goods 99 Act came in force. The act is administered by the Geographical Registry under the jurisdiction of Controllers General of Patents, Design and Trademarks. Again, the provision is very, very big. So this is not a very much legal talk. So I would just skip those. So then I would come to the Copyright Act 1957, which is again an extremely important and one of the oldest existing intellectual property rights act. It has been amended quite a few times to align with global trade and commerce. The act relates to persons' creativity to it protects the right of literally artistic musical works and sound recordings and cinematograph films. For instance, it provides a copyright to author for his lifetime and 60 years after his death. It does not require to be qualitative work for being eligible for the registered under this act. Any unique work with very little in common with any other work can be considered as eligible for the purpose. Under the copyright, the author not only get right to the authorship, but also get the right under which without his prior permission, his work cannot be amended. If any amendment which may done against his will can be brought into the court by the author, and he can get order to recover any kind of damage and stop such act immediately. Then come the Protection of Plant Varieties and Farmers' Rights Act 2001, where India has seen the growth of the industry of research of plant breeds to give protection to researchers and to encourage their interest in discovering better breed of plants. Idea of the plant breeders' right came in exist. It promises to sustain agricultural progress as having vast portion of land of India being agricultural lands. It is very, very essential. It makes up trips under Article 27 of it. It was necessary to give protection of plant varieties by patenting or by an effective SUL generation system or by any combination thereof to effect to the same. The government introduced the Protection of Plant Varieties and Farmers Act in 2001 to encourage development of new breeds of plants. Though this work has been not promoted a lot, and it needs a lot of more research to develop new breeds and identify whether this has been done before, etc., in Indian subcontinent. But it needs a lot of resources, researches, everything. But yes, it can stop the countries to dupe the Indian farmers for better quality of seeds. Even after a lot of technological advancement which has taken place in the end of 20th century and beginning of 21st century, there came the Semiconductor Integrated Circuits Layout Design Act. In past 3 decades, information technology and digital industry has seen biggest development, the development also getting paced day by day and can be called fastest growing sector of the century. The industry has seen significant change in electronic equipments, computers, telecommunication, etc. And also it has affected human life in the biggest manner by providing advancement in many ways. Microelectronics, which primarily refers to integrated circuits, ranging from small scale integration, that is SSI, to very large scale integration, that is VLSI, on a semiconductor chip, has rightly can be called the core strategic technology world over, especially for information technology based society. Integrated circuits requires expertise, knowledge, and the effort to create one depends on complexity of the output. Hence, it is very necessary to cover the same under IPR, and it is also necessary to encourage continued research and develop in the field of microelectronics. Right. Also, there are very uncommon things which are came under this. One of them is a trade secret, a confidential business information that provides a business an edge to a competition can be considered as trade secret. Such information can both be manufacturing and commercial secret. A trade secret can be protected for an unlimited period of time, but a substantial element of secrecy must exist so that except by the use of improper means, there would be difficulty in acquiring the information, right? So considering the vast availability of traditional knowledge in the country, the protection under the will be very crucial in reaping benefits from such type of knowledge. Like I would rather say the unutilized old Indian knowledge. Utility models. A utility model is an exclusive right granted for an invention which allows the rights holder to prevent others from commercially using the protected inventions without his authorization for a limited period of time. In its basic definition, which may vary from one country to other, a utility model is similar to a patent. In fact, utility models are sometimes referred to as petty patents or innovation patents. Now we want to go to the difference between types of patents. Let us directly come to the latest developments which are being taken place. Mostly by the government of India and of course the people of India. The National Intellectual Property Rights IPR Policy 2016 was adopted in May 2016 as a vision document to guide future development of IPRs in the country. It's a clarion call is Creative India, Innovative India. It encompasses and brings to a single platform all IPRs taking into account all interlinkage and thus aims to create and exploit synergies between all forms of intellectual property, concerned statutes and agencies. It sets in place an institutional mechanism for implementation, monitoring, and review. It aims to incorporate and adapt global best practices to the Indian scenario. Now, the Department of Industrial and Promotion of India, Ministry of Commerce, Government of India, has been appointed as the nodal department to coordinate, guide, and oversee the implementation and future development of IPRs in India. The Cell for IPR Promotion and Management set up under the Aegis DIPP is to be the single point of reference for implementation of the objectives of the National IPR Policy. India's IPR regime is in compliance with the WTO's agreement on trade-related aspects of intellectual property rights. A main objective of Indian government to promote IPR in such a manner is to create awareness, outreach and promotion, to create public awareness about the economic, social and cultural benefits of IPRs among all sections of the society, generation of IPRs to stimulate a generation of IPRs, stimulate the youth of India so that they get more motivation to create something new and go for more innovation and creativity and can protect those innovative and creative things from the misuse of other people. Now, legal and legislative framework is also important to have a strong and effective IPR laws which balance the interest of rights owners with larger public interest, administration and management to modernize and strengthen service-oriented IPR, commercialization of the IPRs, get value for IPRs through commercialization, enforcement and adjudication to strengthen the enforcement and adjudicatory mechanism for combating IPR infringements. Lastly, human capital development to strengthen and expand human resources institution and capacities for teaching, training, research, and skill building in IPRs. So with this, the achievements under the new IPR are Improvement in GII ranking, India's ranking in the Global Innovation Index issued by WIPO improved from 81st in 2015 to 52nd place in 2019. It has further improved, but I do not have the latest data after the COVID lockdowns. Strengthening of institutional mechanism, clearing backlog, reducing pendency in IP applications. Augmentation of technical manpower by the government has resulted in drastic reduction in pendency in IP applications. Automatic issuance of electronically generated patent and trademark certificates has also been introduced. Now, increase in patents and trademark filings because of so much of knowledge to the general people, which was given by the Honorable Government of India. Patent filings have increased by nearly 7% in the first 8 months of 2018-19, vis-a-vis the corresponding period of 17-18. The trademark filing have increased by nearly 28% in this duration. IP process re-engineering. Patent rules 2003 have been amended to streamline processes and make them more user-friendly. Revamped table marks rules have been notified in 2017. Creating IPR awareness programs have been conducted in academic institutions, including rural schools, through satellite communication and for industry, police, customs, and judiciary. Lastly, technology and innovation support in conjunction with WIPO, TICSCs have been established in various institutions across different states, right? So beside that came up many more. Concern to the pharma companies, there had been issues which come up at the section 3B of the Indian Patent Act in 1970, which did not allow patents to be granted to inventions involving new forms of a known substance unless it differs significantly in proper with regard to efficacy. So this created some problem. Pharma industry rejecting the patent for Novartis drug, which is called Glibi. Now, issues of compulsory licensing, CL is problematic for foreign investors who bring technology as they are concerned about the misuse of the CL to replace their product. It has been impacting India EU FTA negotiation. CL is a grant of permission by the government to entities to use manufacturers, import or sell a patented invention without the patent owner's consent. It was also permitted under the WTO's TRIPS agreement, provided conditions such as national emergencies, other circumstances of extreme emergencies, and anti-competitive practices. India continues to remain on the United States Trade Representative's priority watch list for alleged violations of intellectual property rights. In the latest Special 301 report released by the United States Trade Representative, the US termed India as one of the world's most challenging major economies with respect to protection and enforcement of IP. It has also looked after the data exclusivity and informants of Copyright Act. Though the last one is weaker, but yes, the exclusivity of data is being done quite often in today's world. Then came promoting an environment of innovation in schools. So this type of entrepreneurship-oriented, innovation-oriented, creativity-oriented programs were launched in academic curriculum. A proper resolution of mechanism for resolving IPR-related issues if needed. India will be unable to take full advantage of the transformative benefits of a strong IP system unless and until it addresses gaps in its IT laws and regulations. Success of India's flagship program, Make in India and Startup India, depends on the boost of innovation ecosystem with the better IPR safeguard. More awareness is needed about the creation, protection, and enforcement of IPR to encourage the Indian industry not only to innovate, but also to protect and enforce their innovations. Now, coming back to this year, the theme is IP and youth innovating for a better future. It is an opportunity for youth to find out how IP rights can support their goals, help transform their ideas into reality, generate income, create jobs, to make a positive impact on the world around them. With IP rights, young people have access to some of the key tools if they need to advance their ambitions. In order to continue with the series on tools aimed at the focus of creativity and the improvement of abilities and exploratory attitudes, quite useful in the design process, today we present the skill thinking hats. This is what which I would say is the most important one for today's world, because if you really want to go for innovations and creativity, create something totally new, you have to wear different kinds of hat at different point of time. Now this says this six thinking hats, which says blue one, it says the process, which says thinking about thinking, what thinking is needed, organizing the thinking, planning for action. The white one says informational, data neutral and objective. What do I know? What do I need to find out? How will I get the information needed? Then got the red hat, intuition, hunches, gut feeling. The feelings right now, feelings can change later on. No reasons are given. Apparently there's no reason. Green hat, creativity, ideas, alternatives, possibilities, solutions to black hat problems. Yellow hat, that's benefits, it's positive, plus points, why an idea is useful, logical, reasons are given. Lastly, black hat, which is a caution, where difficulties, weakness, danger is spotting the risk, logical reasons are should be there. Logical reasons should be explained. So we can see, like, being a single human being, if you change your way you think, every one of us, we have that creative seed inside you. And by a little change of the, uh, the main upper part, one can go for a major innovation, major creativity, and land up in, um, you know, something with a very divergent thought process also. Right. So the six hats method can be used in sequencing. First of all, to explore the problem, then to develop a set of solutions, and finally to select a solution through critical analysis. So I would like to conclude right now. It says, like, India has made a number of changes in its IPR regime to increase efficiency and has cut down the time required to issue patents. The culture of innovation is taking center stage in the country. India is well poised to focus on R&D. This has been reflected in its improved ranking in Global Innovation Index over the years. Government's effort to strengthen national IPR policy, IP applicants, tribunal e-governance, and commitment to ability by the TRIPS agreement of WTO in letter and spirit will help in improving perception of India and globally. An efficient and equitable intellectual property system can help all countries to realize intellectual property's potential as a catalyst for economic development and socio-cultural well-being. So here it is the end of what I thought of speaking, but there are two things which I would like to tell you very informally. Number one, to be in today's world is changing every day, every moment. So it is not possible for anyone to invent something 5 years back, 10 years back, and carry on with the same product right now, right? So there have been a lot of emotions in uh, all aspects of life. So to cater to this, you need to be extremely creative and innovative and come up with thousands of ideas. You need to select a problem
and come up with thousands of ideas to solve that. You don't know which idea is the best one. And then by trial and error, you try and find out which one is the best one and which is not there with someone in your vicinity, in your country. And once you have invented it, when you have created it, it's like your own baby. So you will obviously look for its protection and you will go and file IPR and do. So before filing an IPR, before having an intellectual property, what you as a student need at this time is a lot of work, a lot of creativity, a lot of innovation, and coming up with new models every day, so that even if first one is not accepted, second one is not accepted, at least third or fourth one is going to get accepted, right? So keep on being creative, keep on being innovative, innovate new things, and get it protected by different IPR laws. Thank you.
Yes, Mr. Chakraborty, I'm over. Am I audible, Mr. Chakraborty?
Yes, ma'am, you're audible. I'm Subhashish Shah. Hello. ma'am.
Yeah.
Are you? Yeah,
Uh,
ma'am. I'm calling Rajoshi sir so that we can conclude this session.
Yes.
Please wait, ma'am. Ma'am, please wait for some time. I called him due to some technical problem. He was not audible.
Hello.
Yes, you are audible.
Hello, am I audible? Hello.
Yes, you are audible.
Okay. So we have concluded our session from wonderful session from our honorable speaker Surjashika madam. So in this note, I would like to say that today our speaker Surjashika madam presented and demonstrated very well to our students and to us also the scope and benefits of IPR as a student, academician, and entrepreneur, defined ways of filing the patent, multiple example of latest filed innovative idea or product in accordance with IPR laws, latest footstep, achievement, etc., as well as types of intellectual properties and their description, how IPR will be defined with different industries like that. The session and explanation on various topics were really enriching and cultivated great interest in the minds of the participant and appreciable also. The presentation was an engrossing experience for all of us. The participants followed by an interactive session like right now. And we are really very much thankful for you, ma'am, for your valuable and wonderful presentation. So on this, with the permission of you, madam, and our honorable IIC President, madam, IPR cell coordinator, sir, and other faculty members, and obviously our honorable principal, madam, for her enormous effort all time. And this wonderful webinar happening from IPR cell and IIC. Also, we are concluding here. and ending today's program. So before that, I must request, I would like to request our host, Sir Subhasis Sir, to showcase the memento, digital memento, as a token of appreciation for Sujyashika Madam. Madam,
Thank you
please
so much, sir.
accept
I'm
this.
really honored. So I would be really
Hello. Hello.
Am I
Madam.
audible?
Please. Yes, ma'am,
Yeah.
right now.
I'm telling like, thank you so much. I'm really honored to have this. So if you can please send me, email me this one, I would be,
Definitely, definitely.
thank you so much. Thank you very much. And thanks for giving me this chance to interacting with the students of GKCM.
Thank you, ma'am. Thank you. We are also honored, and we will keep in touch.
Thank you.
Thank you, ma'am. We will send this by mail. Thank you, ma'am. Thank you, all of you. So we are concluding and ending.